So I am Eva Hager. I am an attorney with the firm, and we are going to talk about the basics of elder law with a smattering of Medicaid built in. So something that I think is important for this entire group as we journey through our life. So let's get started. All right, so anybody looking at the slide, can you tell me what the things are that the traditional elder lawyer does? Wills, trusts, estates, things like that. Those all have in common money, right? We're looking at protecting assets. We're looking at protecting things. But have we really done our jobs if we're not looking at your quality of life? When we talk to any of our clients, we talk about the elder care continuum. What is the elder care continuum? Well, it's just life. We're all on it, whether we want to be or not. But we have different stages in the elder care continuum. Now, most of you are probably at home with full functioning, and you are having low costs of care, not really any worries there. And so there's no real reason to discover the world behind the curtain because things are going great. But much like Evel Knievel here, we all have a hope. And what is that hope? That hope is that we skip this entire conversation, we don't have to listen to that boring elder law attorney talk, and that we crash over at the grave without ever having to think about any of this. And if I am going to preach one thing today, it is that those who don't plan might suffer a bit of a problem if they crash somewhere in the middle. We are a life care planning firm. What is life care planning? Again, the traditional role of the elder law attorney is to make an estate plan for you, to prepare for after you have left this world. And right now, many of you may be in the retirement plan era of what am I going to do with this newfound freedom that I have as I have left the working world? Those who crash in the middle, though, learn to meet a new challenge. And that challenge is, what happens when your function decreases? What happens when you might need a little help at home? Or what happens when it's maybe not safe to be at home anymore? What happens when things go even further than that? When independence is achievable, but in some type of facility, right? Then you start looking at increased costs with those losses of function. Then you start looking at increased needs for ways to pay for that care that you need. So what are we trying to do? We are trying to prepare to help you bridge that gap, to help you swim over the sharks, so to speak, of what you might be facing. Life care planning is a holistic way to practice law, and I love it because in my old world, I had a whole multidisciplinary team that helped me serve my clients' needs. And in this world, I have that as well. Back there taking a picture of me is Lisa Titus, one of our elder care coordinators. She's got extra folders if any of you have needs of those. My presentation is in the folder so you can take all of this with you. But Lisa is the special sauce, and our other elder care coordinators, to what our firm does for our clients. We help families navigate the care maze as you're moving through that elder care continuum. Now, sure, we do documents, we do the law stuff, but that's not the exciting stuff. The exciting stuff is, oh no, my loved one is facing a discharge from the hospital to a skilled nursing facility. And yes, okay, that's fine. But what happens after that? Will my loved one be able to go home? Will my loved one require additional care in the home if we go home? Will my loved one not be able to reside in the home safely anymore? Where are we going to go? What's the best place? What's the best place for our finances? What if your loved one is in care and there's a change in care circumstances? I was just having a conversation with a lovely woman before the presentation. We have elder care coordinators that jump right in, right? And they help families navigate those shark-infested waters. So, obviously, it's a multidisciplinary team approach. Now, you'll see Dennison and I on the side, we're the boring suits. Molly, Myrnie, Debbie, Brittany, and Lisa and Leanne, they're what makes our firm tick. We talk through with each client the concept of, okay, where are we at in the continuum? What do we feel is the next step on the journey? How do we prepare you for an emergency crash on that journey? And how can we make your life and your care good throughout? We're the confluence of law and care, so that you can succeed through that journey. Now, here's the part that you really came for, which is, what do I need, Eva? How do I really make this journey the best for myself and for my loved ones? Now, you need 2 documents, preferably 3, and those are your healthcare advance directives, right? Your healthcare power of attorney and your living will, and your financial power of attorney. Now, I'm sure many of you in this room have these documents, but we're going to have a bit of a discussion as to what they are, how they work, and what you need to look for in your existing documents. So, healthcare powers of attorney, those of you in the care industry, I am sure, are very familiar with the concept of it is a document that names a person to make healthcare decisions for you when you can't, okay? Now, it's not always a life and death decision. It can be as simple as, I'm going to transport you to a different facility, right? But remember, this goes into effect even if you are just in a temporary state of unconsciousness. You need to have someone to make those decisions. And a lot of people are like, well, Eva, I have that person. My spouse is named. I'm good, right? A lot of people don't think through the concept of, well, what happens after my partner is gone, right? Maybe there's one kid as a backup, but do you have multiple backups? Have you checked on that recently? Take a look at that document and make sure that the persons you've named are still the persons that you would trust to make the decision to let you go into surgery. Then there's the living will, right? The living will is where you, the patient, are telling the doctor what you want done if you are at the end of your life. It takes the point of view that you do not want to be kept going if you are at a point of terminal illness and or a permanent unconscious state. So everyone's like, Eva, I want to make my own decisions. And don't worry, right? The living will only comes into effect when, again, you can't make your wishes known. But for a lot of people, that gives grace to their loved ones, right? They make the decision for themselves. It helps one pass with dignity. And so they're taking that decision perhaps off of a child. Now, it's important to know that that living will trumps the healthcare power of attorney, right? Because you yourself are the patient. You yourself are saying, Doc, this is what I want done at the end of my life. Most important is a strong financial power of attorney, right? Now, this is a document that takes effect during your lifetime. It's live and hot if you make it so. A lot of people have springing powers of attorney, and those have a role to play, but in real life, when you're not able to handle your own finances, do you really want your child to have to go to a doctor to have you declared incapacitated? And what's in it for the doc, right? Hashtag lawsuit, right? No one wants to be in a position where they need to use the document, but there's a barrier to entry. So take a look at your old financial power of attorney and think, is this really what my child or my spouse needs to take action for me, okay? That being said, you are giving away the keys to your castle. You are letting someone act in your name. So we're not just saying willy-nilly give all these powers to everyone. What we're saying is think carefully about who you might have named and whether or not they need the powers that you're going to give them. So standard powers in a financial power of attorney include the power to bank for you, right? The power to write checks, to sell real estate, to deal with your investments, to borrow money. But maybe you got a financial power of attorney in your 40s, right? Maybe it doesn't have all the powers that you need, or maybe like this one, it's just way too general, okay? When you're a financial institution and you're looking at those powers of attorney, you want to know that the person giving that power really thought about what they were giving away. If I'm a banker looking at this, I'm going, all reasonable to do and perform each and everything whenever requested. I want some more specificity. So the state of Ohio does you a solid by putting a wonderful statutory power of attorney in its own laws. And we see a lot of these in our practice, all right? But it's kind of hard to use them correctly. Now, if you're looking at this and you're seeing, oh, okay, actions requiring express authority to create a trust, to make a gift, to create or change beneficiary designations, you're thinking, okay, if I just print this out and sign it, I'm good to go, right, Eva? Well, no, that's not right. Because what you're not looking at is the paragraph above it, which says, unless expressly authorized and initialed by me in the special instructions part of this power of attorney does not give those powers. Now, there's an excellent public policy reason behind that, right? We don't want to just give those powers willy-nilly to, the son-in-law that maybe has a problem with gambling, right? You don't want him to be able to gift to himself, probably, right? And so we don't put that in the generalized statutory power of attorney. But people in an emergency are just looking for, okay, I got to get a bill paid, right? I'll fill this out, I'll do it myself, and I'll do it correctly. Take a look at what you've got. Now, I've talked about the power to gift, the power to handle your retirement accounts, the power to create a trust for you, the power to self-deal, right? To give to the agent to give to themselves. We don't want to give that to the gambling son-in-law. The power to appoint an authorized representative for a Medicaid application. These are the powers that we, as the lawyers, are talking with the client about and saying, hey, these are really useful powers to you. And I'll talk more about that in the Medicaid portion of my presentation. But you've got to give them carefully. And you've only wanting to give them to the people that you trust, all right? We will talk a little bit about gifting in that Medicaid context. But what you want to do is have a conversation with your lawyer about your documents before that emergency takes place. Because I can't tell you how many families come into our office and it's like, well, okay, I've looked at the document that you have. At this point, the elder is not able themselves to execute a new document, and it just doesn't have the power to gift, right? We cannot go back and fix it at this point. So again, here's the lawyer saying, plan ahead, plan for the worst. I know it's not fun to think about. I know it's uncomfortable to have those conversations with your children, with your loved ones, right? But in part, that's what we do. We're facilitating those tough family conversations of, if I look like I'm going into long-term care, right, how do I make sure the documents have the power so that the healthier spouse can do what needs done, so that that eldest daughter can do what needs done? So without that strong financial power of attorney, what happens? You end up in a guardianship, okay? And a guardianship is a court process, and thank God we have it, right? It's appropriate. A court is watching everything that gets into the estate and out of the estate. So it's an ongoing, cumbersome process. Everything is public. You can go to the probate court website and noodle around, and everything is controlled. Wouldn't it be easier to have your loved one or your family member doing that for you? And the answer is yes, but you need to have that strong financial power of attorney in place. What do we need to sign that strong financial power of attorney, Eva? Well, the elder needs to know the nature and scope of what they're doing. right? You need to be able to understand that that gifting power can be used for good. That gifting power can be used to protect assets for the family, make sure it doesn't go all to the facility. That gifting power can be used to give a house to a caregiver that has stayed in the home with the parent for 2 years. That gifting power can be used to deal with maybe a Medicaid penalty that a family didn't expect. But that the principal needs to understand, hey, Susie has the power to sign that deed to transfer the house to herself, to take money out of my pocket, okay? And so you have to understand the nature and the scope of the positive aspects of the document and the dangerous aspects of the document. What about dealing with retirement accounts, changing beneficiary forms? You've looked at all your retirement accounts recently, haven't you? I know you've all been just raring to go with checking your beneficiaries. Well, that lawyer said, check your beneficiary forms. I bet you filled them out like me, in your 30s, in your 40s, when you switched that job and you moved that IRA to the rollover company. Were your family circumstances the same? What if there's something that happens to you and your agent needs to change those forms to make up for something that's changed since that first designation that you made? If that agent's your eldest daughter and she doesn't have the power to self-deal, then sure, she can change the beneficiary forms to her brother and her sister, but she can't change it to herself. She can't treat herself equally to her siblings. So, to quote a great comic book, with great power comes great responsibility, right? I'm not saying these are the right choices for your family, but I am saying you should have the conversation about what powers would be appropriate to have and who you want to give them to. So, let's talk a little bit more about Medicaid. We always like to say keep your eye on the Medicaid ball. And why? Because it's really complex, all right? Medicaid we often think about as the three-headed monster, and that's in our office. And that's not to say that the people that administer it are terrible. No, they're good public servants, right? I was in public service. I admire them. That being said, right, it is still a bear to deal with. A bear, or a three-headed Godzilla. So what do we think of as Medicaid in the context of elder law? We think of Passport, which is Medicaid for the home. We think of the assisted living waiver, which is Medicaid in assisted living facilities. And of course, the traditional nursing home Medicaid. And I'll talk about each of those in turn. Passport is a program that allows an elder, once qualified, to get up to 40 hours of care in the home, right? That's great for couples. That's great for if there is a child maybe living with the family and they can handle sort of nights and weekends. That helps a family stretch their existing resources over time by paying less for in-home care. But there are some hoops that you have to jump through, all right? If we want to have that family caregiver, they have to train through Medicaid and be certified. Again, it doesn't quite help without extra support, so it's not an ideal program for single people. And it's sometimes difficult, especially in rural areas, to find providers. So we help families know what providers are accepting of Passport in their area, and we help families work through any issues that they might have with their care providers if they occur. But like all Medicaid programs, you have to qualify from an income perspective, from a level of care perspective, and from an asset perspective. More on that later. But in this situation, a doctor has to say, okay, you are at the level of need for services where you could be in a nursing home. What about that? Well, that means you need help with at least 2 activities of your daily living, So help with feeding, dressing, bathing, toileting, continence, or transferring from bed to chair. Assisted living. Great, Eva, there's a program that helps us pay for a stay in assisted living. There is. However, there's a catch. Most facilities here locally don't accept the waiver just from jump, right? That wouldn't work for their business model, and I respect that. So what we're helping you look for is facilities that will accept it over time. Often, here locally, that's 2 years of private pay that you know mentally, I'm going to have to pay for this before I can roll to the waiver as a payor source. And again, to cite a conversation that I had earlier with another wonderful attendee, you're not necessarily guaranteed that that Medicaid bed is going to be available for you when you get to that point. So how do you know what facilities you're likely to be able to stay with? How do you know what to do if you suddenly get that notice of, oh, I'm sorry, we're not going to have a bed for you on the nursing side? That's where, again, those elder care coordinators are the special sauce of the life care planning process. And then finally is traditionally what we think of as Medicaid in the nursing home. So let me do some myth busting here, all right? Every Ohio facility, right, accepts Medicaid or can accept Medicaid. And it's a myth, right, that Medicaid facilities are the worst facilities. Again, it's just a matter of accessing that bed within the facility of your choosing, okay? And that's where we get to, they can limit the number of Medicaid residents that they accept. So how do we find that good facility? How do we find that facility that we think is going to be able to have that bed for your loved one? If it's a crisis, if we need it the week after next, Lisa's making those calls, Debbie's making those calls. And based on their knowledge of the industry and based on their contacts, because they're finding these for clients every day, that's what our firm helps your family do. Now, we talked about the finances briefly, and now I know I can see your eyes glazing over already. We're back to finances. But this is really important stuff because it's not just your level of care, it's what you have and what you make. Medicaid requires you to put any excess income you have into something called a qualified income trust, all right? If your income exceeds $2,523, right? Any extra income you have has to go into this box, so to speak, okay? All I want you to think about it is as a tool that allows you to qualify for Medicaid. But I can't tell you how many families come to us and they're like, Eva, Medicaid says we need a QIT. How do we create one? Okay? Then there is what you have, your assets. I had a gentleman come up before, ask me, Eva, will I be able to protect a house? And of course, my answer was a very qualified, in the short term, yes, right? Because if you are a couple, you can protect the house you're in, and that'll be the next slide. In Ohio, though, you have to spend down to $2,000 worth of assets. You can, in the near term, maintain the home with what's called an intent to return, and you can keep one car as needed for medical transport. But here's something major, and that's going to continue to be major as we continue to move forward in time, because Ohio has now made firm that IRAs in payout status, that retirement accounts in payout status are off the table for Medicaid eligibility. Now, again, that's fantastic news for families. That's fantastic news for especially community spouses, because that's a way of preserving assets for that community spouse to be able to live when the institutionalized spouse passes away, okay? So that is a big deal. Now, what do we do if we've received perhaps a tough diagnosis? What do we do if we're under the age of 72 and a half when we're required to take those minimum distributions? We put the accounts in payout status anyway. And Medicaid has said that even a small regular payout is enough to take that account off the table, which is fantastic. Now, here we are at the couple, right? Again, good public policy. If one spouse is in the facility in long-term care, we want the other spouse to be able to stay in the home, okay? And we don't want the family to have to spend down to the nubbin. So the community spouse can keep up to a cap of about $150,000, okay? What do we take off the table? Again, the house. What do we take off the table? A car. It can be the fanciest car you decide that you want to purchase. Pay down the mortgage on that house? Also, an excellent potential idea, right? And then those retirement accounts, again, in payout status. So, what do we do in a situation when we have to qualify someone for Medicaid in that crisis? What do we do when we have to spend down to that level? Because again, about $150,000 is the maximum that you can keep. Let's say all you have between you at the time Medicaid takes a snapshot of your finances is $150,000. Well, Eva, what's that snapshot? That snapshot is the first 30 consecutive days that you're in the hospital or that you're in the facility. Okay, so let's say at that point you haven't talked to a lawyer, you haven't pre-planned, you haven't said, oh, okay, I need to always make sure I have this much cash on hand so I can get the highest possible amount for my spouse to be able to keep. Well, at that point, we have it. So if you have $150,000, then you have to spend down to $75,000, right? And that goes all the way down to a cap of about $30,000. What can you spend your money on? You can spend your money on burial spaces, both single and couple. You can spend your money on prepaid funerals that are irrevocable, meaning you can't go back and change the contract. Again, you can spend money on the house. You can fix up the house. You can pay down debt. You can buy that new fancy car. But there's a cost. You know how I said, oh, we'll protect the house in the short term? Yes, great, wonderful. However, the cost is Medicaid estate recovery. Now, what is the deal that we make with our fellow citizens when we're asking our neighbor to pay for our care? We make the deal that we're going to spend on ourselves. We're not going to give our money away. Okay? And in exchange, then we can say, okay, neighbor, help me pay for my long-term care in the form of Medicaid. But the cost is estate recovery, which means the state will come after those assets that the institutionalized spouse had in their name at the time of their death. So, what is that potentially? For the singleton, that house that they had an intent to return to. Right? In the case of the couple, the Medicaid estate recovery doesn't happen until after the death of the community spouse, right? So let's say, in traditional terms, maybe the husband is in long-term care and the wife is the community spouse. The wife gets to keep living in the house. The wife gets to protect the house. The wife gets to protect the car. The wife gets to protect the money that she didn't have to spend down to. But after she is gone, then the state of Ohio can file a claim against the house. And that claim ultimately will get paid off after the house is sold. So that house that you wanted to pass on down to the kids, right, suddenly has this lien filed against it for the amount of care expended by the state of Ohio. And I will say, I promised I'd reference this, Ohio will go after what's left in the IRAs. So, do we know what that's going to look like? No, in fact, we don't. It's going to be the wild, wild west out there. But it is something to note that it's the comfort of knowing that I will have that resource. I will be able to live comfortably with that resource after the institutionalized spouse is gone. That's a great thing, okay? But it is something to note that if we're not getting assets out of the institutionalized spouse's name, then it can be subject to estate recovery. We talked about how we want to protect assets. So, what is one of those tools? Well, we can move that house to the wife, right? But what if the husband can't sign the deed? Then you need that strong financial power of attorney. What if we want to move that house to that child caregiver that is in the home? Then we need the strong financial power of attorney with the power to gift to the child. I talked about the trade-off, right? I talked about the trade-off of when I'm asking my neighbors to pay for my health care, what is my obligation to them? And what Medicaid says is you have to spend the money on yourselves. You can't turn around and give it to your kids. You can't turn around and give it to your loved ones. There's a cost in that you can't gift without being put in the penalty box. Dennison always makes a joke about if he got a tough diagnosis, what would he do with all of the money? He would take a cruise around the world. First class, stateroom, spend all of his money on himself, and on the last day, turn around, come home, and enter into the nursing home. And Medicaid would say, that's fine. Spend on yourself lavishly, but don't turn around and give it to someone else and then ask your neighbor to pay. What is the time period that Medicaid is going to be looking at your spending habits? That's the 5-year look back, okay? Medicaid is looking at all of your accounts going back 5 years from when you're applying, and they're saying, I need to make sure that you didn't give money away to the kids. So, what is a pickle that we often see in our practice? I have, let's say, $400,000, and it's 2021, okay? And I got that tough diagnosis, and I said, I know what road I'm going to face. I know I'm going to likely spend a lot of money on a facility, on long-term care. I'm going to give $100,000 to my kids. They deserve it. They should have something, right? Not the facility. And then I move into 2022. I've got $300,000 left, and I pay $100,000 for care. I move into 2023, and I pay another $100,000. And 2024 comes around, and I've spent my last $100,000. I'm now broke. Let's go apply for Medicaid. Well, what did I do with my money in 2021? I gave $100,000 to my kids. And Medicaid's going to be able to see that, and Medicaid is going to put me in a penalty box. What is the consequence of that penalty? In this case, the penalty is over a year of no Medicaid. And I better hope that my kids have kept that gift. Because otherwise, there's no money left to pay for me, right? I'm in the facility, I'm in the penalty box, Medicaid will not pay for me. At $7,500, a $100,000 gift is suddenly 13.3 months without any Medicaid. So the bigger the gift, the longer the penalty, right? I can't tell you how many families come into our doors and they're like, oh, we haven't gifted, except for that car that I gave my grandson, right? We haven't gifted, except for that money that I spent to give my daughter to fix up the downstairs bathroom so we could live downstairs. Part of what we're doing is helping families through choices that have already been made, okay? What else can we do with money that we have to spend down to that threshold that I was talking about? What else can we do to get our loved one qualified for Medicaid? Well, we can do a couple of things. There are things called pooled trusts. We can use things called Medicaid-specific annuities. And if we have a longer runway than 5 years, shameless plug for advanced planning, then we can protect money for the family through things like a Medicaid Asset Protection Trust. So what are pooled trusts? Again, just think of trusts like a box. Trusts in this situation are an allowable transfer, right, to this pooled trust, and you can use that pooled trust to pay for things that you need while you're in care. Now, what's the cost of that? Again, the state comes knocking at your door after you're gone, and they can seek recoupment for the money that they have been paid, or the money that has been expended for your care ahead of your heirs. But what is the positive? The positive is you draw funds out of that to buy a lift chair, to buy a computer, right? So you can Skype with that loved one across the pond. You can purchase an upgrade to a private room. Most people don't know Medicaid is only paying for a semi-private room in the context of long-term care. And there's a lot of people who've lived a very long time not wanting to go back to living with a roommate. What else can we do in the space of crisis planning? We can use Medicaid-specific annuities. These annuities are a tool to make that extra cash into a stream of income. And we can use that stream of income to deal with a gift penalty that we know we have coming because of that car, because of that bathroom remodel that we didn't appropriately document. We know we can use that annuity to maybe give something on purpose to the kids, right? We can draw the penalty ourselves and thus pass on a legacy to the next generation, but still have enough in reserve to pay through the penalty that we know that we're going to draw. Now, I see a lot of puzzled looks on everybody's faces, and I get that this stuff is pretty esoteric, right? But here's the deal. You don't need to worry about the math. That's our job, to worry about the math. What you need to think about is, do I want to put these powers into my documents? Do I want to have these conversations with my loved ones so that if I face a crisis, the family can get together and carry forward my wish, both of having me get the highest quality of care, having me get the private room that I want, but also to maybe pass something on to the next generation. So it's not all going maybe back to the state in a state recovery. So it's not all going to the facility in the form of payments. That's what you guys need to be thinking about. Well, Ava, you might ask, I don't think I'm going to have this crash. I think I'm doing great. Okay, wonderful. Come talk to us still. We can make a plan to try to protect your assets for the next generation. We put it into a box, but this time, that box isn't changeable. It's an irrevocable Medicaid Asset Protection Trust. And what you're doing, again, is you're taking a bet. You're taking a bet that you're going to make it past that 5-year look back. And if you succeed, everything in that trust is protected for the next generation. Okay? Now, again, what are the details? How much should we put in? What should we put in? Is this even a good idea for us? That's an individualized determination that we help families make. But in this situation, we know that that bequest, right, that asset is protected if we succeed in making it past the look back. So, what are some other tips? Don't commingle assets. Don't reimburse loved ones without keeping receipts. This is my plug for the wonder that is my coworker, Leanne, who helps families untangle 5 years worth of bank statements and explain, oh, well, yes, that $1,500, that was, again, for me, not my child, even though it looks like it went to my child. What's an easy way to help prepare for that Medicaid application down the line? Treat your loved one like they're a business, right? Get a credit card. Have that be mom's credit card and put all of her expenses on that. So there's clear bank statements that you can have that says this is money expended for mom and for her care. What are some other great things that we can do? Well, there's something called the 2-year child caregiver rule. We can transfer a full house without penalty to a child that is in that home caring for the elder for a period of 2 years. What we need to prove, though, is again that the child lived there, right? And that, but for that child's care, the loved one would have been in a facility. So we're going to your doctor and we're saying, hey, did Judy keep you safe and out of a nursing facility for 2 years? Did Judy live with you that whole time? Then Judy can protect the house. And if it's up to Judy, if Judy wants to, she can then split the value of that house amongst her siblings. She doesn't have to, but she could. What if you have a disabled child? Again, good public policy. We want families to take care of their disabled loved ones. You can transfer that house to your child fully, so long as they are formally disabled. Now, there's a bit of a catch there, right? Because if we're doing that, great, we're taking care of the disabled loved one, but there's a risk that we then take them off their means-tested government benefits. And so again, you should be careful doing this because you wouldn't want to hurt your disabled child by giving them too many assets and kicking them off their benefits. How do we handle that? We handle that through special needs trusts. But what is the common thread of everything that I've talked to you about? Having that strong financial power of attorney. If you have that person that you trust, if you have that person that you know would carry out your wishes when you cannot, and critically, can they gift and can they self-deal? So, congratulations. We have made it to the finish line. Eva, what's happening now? Well, you're gone. You don't care. But truly, you do, because otherwise you wouldn't be talking to an elder lawyer at this event. If you die without a will, right, the state of Ohio decides where your assets go, right? And that typically follows your family. But what if you don't like your family? So that's a plug for, hey, maybe we should make a will. They give you a measure of control. They give your assets to who you want them to go, and in ways they can be used to protect things like minors. That being said, there are things that a will doesn't cover. Remember when I was talking about those beneficiary forms and going to check on those? Here's your reminder. We're circling back. Anything that passes by beneficiary form circumvents that. I'm going to cut through the illustration just to say, go check your forms, okay? Make sure if it's going down to your kids, then it's not just going down to your kids themselves, but their kids. Can you make a per stirpes designation on your form so it goes down to the grandkids level if, God forbid, something happens to one of your children? Now, what do we have besides wills? We've got trusts. And everyone's like, oh, Eva, those are for rich people. No, they're not, all right? Trusts make your loved one's life easier by avoiding the hassle that is probate court. Now, I know all of you are sitting here right now thinking, Eva, I'm worried about the federal estates tax sunsetting and going down to probably something around $5 or $6 million. We're not really worried about tax consequences at this point, but we might be worried about a spendthrift grandchild. We might be worried about a blended family. We might be worried about privacy. This is Dennison's favorite slide. Guess what? Marge Schott died with a will in Hamilton County. You can look it up on the probate court website, and you can see everything that she had. And the second I tell people that, they're like, oh, I didn't really think about it that way, Eva. Maybe I am more interested in getting a trust. Trusts are also appropriate for protecting those special needs children, right? And those are wonderful to use in conjunction with stable accounts, which lets disabled adults actually save for their futures. And finally, trusts sometimes, your trustee, usually also the same person that will advise should be your financial power of attorney agent, sometimes is seen as having more heft with a financial institution. So, how does this all fit together? Shameless plug again. The suits on the side do the legal work, and the amazing care team does the rest of the puzzle fitting. I am so proud to help families get through all of their journeys, whether it's from Parkinson's, whether it's from Alzheimer's, or any of the umbrella diagnoses, whether it's from reasons that they just come to us thinking, hey, I probably should plan for this. And the answer we always give them is, this is the gift that you're giving your loved ones by having these conversations with us. So, plan ahead, don't stick your head in the sand. And I know I've run a little bit long, but we got started a little bit late. And if you have any questions, I'll be at the table in the lovely atrium. And thank you so much for letting us present and for letting us join this wonderful, wonderful event.